But I thought I'd just quickly, by way of background, go through with you how the court deals with property disputes, because that might help in understanding some of these cases and what their impact is. So if you have a look then at slide 3, with any matter that comes before the family court, the court applies what's called a 4-step process. So there at step 1, the court identifies the pool, so they have a look at what assets there are and what liabilities there are. Then at step 2, the court's going to assess the contributions of the parties. Oh, thank you. So the contributions are the financial contributions, so of course who's making the money and who's buying what, and have there been inheritances and all of those things. But the court also has a look at the non-financial contributions, so that's things like renovations, landscaping, really any sort of manual labour that has worked to increase the value of the properties. The court then, of course, has a look at the contributions as homemaker and parent of the children. So then, oh, there we go. So once the court's done that, they have an overall look at it and see whether or not it's just and equitable. So that step 4 is a bit of a convenient excuse for the judges to change their mind and make a different assessment, depending on whatever circumstances are in front of them. So that's all well and good. What we found is that when looking at the history of all of the judgments passed in those courts, is that in a long-term marriage where you have the husband working and the mother at home looking after the children, the court usually makes an assessment that the financial contributions are about the same as the non-financial contributions and as the contributions as homemaker and parents. So what that means is when husbands are working 30, 40 years and the wife is at home, the court ultimately makes this 50% assessment. Now in most cases that might be fair enough, but sometimes you have what we call the big money cases. And that is where one of the parties, usually the husband, but not always, has a particular skill or knowledge or business acumen that has meant that the pool is significantly larger than what it otherwise would have been. So this is more than working hard. This is having some special skill that the court then, having a special skill that basically meant that this pool was significantly more than what it was. So the court found that it wasn't really fair in cases like that. It wasn't really fair to order 50% to the other person. So the court then sort of developed this notion of special contributions. And basically that enables the court to make a further adjustment based on this special business skill or special financial acumen from one of the parties. So that saw cases like JEL that involved a marriage of 20 years. There are 3 children, and the asset pool was $37 million. Now, the majority of that asset pool came from the sale proceeds of a business venture that the husband was involved in. Now, if we have a look at that, and if we apply the contribution steps and find, contributions more or less equal, is it fair then that the wife would receive half of that? The courts didn't think so. So the court acknowledged some special contribution on behalf of the husband. And in the first instance, they ordered the husband 65% of the pool. Now, you're probably laughing at the fact that the wife appealed that. And on appeal, the court actually ordered 72% of the husband. So, potentially some pretty poor advice that she got in making that appeal. But then we saw matters like McLay, which again involved a relationship of 21 years. There was 1 child. The pool here was $8 million. And again, the majority of wealth was accumulated through the husband's financial activities. So the court found that the husband's contribution exceeded those of the wife's, and because of that, he gave the husband 60% of the pool. Now again, we see the same thing in Kane. 29-year marriage, there were 4 children, there was an asset pool of $4.2 million. Of note in this instance, the asset pool was made up of $3.5 million in super. Now that super came about due to an investment that the husband made. So initially the super was about $1.1 million and the husband decided to make this particular investment, and because of that we have this $3.5 million. So when it came before the trial judge, the judge acknowledged that. He acknowledged the special contribution made by the husband and he ordered 63% to the husband. But then the wife appealed. So the decision came down just a few months ago, and on appeal, the judge said, well, hang on a minute. We don't consider that to be a special contribution. That was one decision, not a series of decisions made over a period of time. And also, the husband had no special knowledge or special skill. He more or less just made a calculated risk, a calculated judgment that may not have paid off. And in reality, if it didn't pay off, the wife would have been required to share in that loss. So the court said under the circumstances, no, we're not going to call that special contributions. And so they sent the matter back down to the lower courts to be reheard. And so the decision came through just a few months ago, so it hasn't yet been reheard, so we don't know what the outcome will be, but probably be closer to that 50%. So what that says, I mean, again, it's difficult to determine exactly what that will mean because there haven't been other cases yet that have relied on that. But really what we can see is a bit of a tightening of this idea of special contributions, and really we can see that it has to be over a period of time. It has to be a series of decisions. It can't just be one investment, one decision. So that's that, and then let's have a look at de facto relationships. If you're in a relationship for 2 years or more, or you have a child together, or one party makes some contributions, then you can make an application for a property split and be dealt with in the same manner as a married couple. So that might seem fair enough, but I once acted for someone who was in a relationship for about 4 months, living with this lovely lady. She became pregnant and they separated pretty quickly afterwards. She then, at separation, and once the child had been born, wanted 40% of his property, and she also wanted to move to Cairns with his child. So we went along to mediation, and I thought that was ridiculous. 40% for a 3-month relationship, just because they had a child together. You know, if they'd never lived together, she would have no claim whatsoever. So at mediation, upon my advice, his offer to her was that he would buy her a suitcase and a plane ticket to Cairns, and that was it. And needless to say, it didn't actually settle, but we knew that, and she didn't take it any further, mainly because her case was very weak, and we knew that she didn't have the financial resources in order to bring the application, because applications are very expensive. However, had she had the resources, my client would have had to face that, and he would have had the legal expenses of responding to that, coming to court, he would have needed the time off work, and all of those things add up and they affect your life, and also, of course, the emotional stress of it. So while at the end of the day, the court may not have ordered much, he still would have had that to deal with, and that's because of this, this section. The same with this one party making financial contributions. I acted for somebody who had accumulated a lot of wealth over a period of time, mainly from previous divorces she was involved with. She was a bit of a serial client of mine. We made each other lots of money, it was great. But anyway, she met this fellow and he moved into her house and they were together for probably 6 months. They separated and she thought that was the end of it, but then all of a sudden he filed an application and served her with it. And she called me up and said, what the hell is this about? We haven't been together for 2 years. So I had a look at the documents and she had been building a house. You know what he said in his affidavit? I've been out to the property. I'm there all the time. I'm building this property. Therefore, I have an equitable interest in this property. Therefore, I want 500 grand. Okay? So I picked up the phone and I telephoned the builder, because she had hired a builder and she had hired contractors, and I said, take a listen to what old mate has said. And I read out certain passages from the affidavit. The guy's a bit of an asshole. Not the builder, the ex-boyfriend. So the builder said, oh no, Jacinta, that's not what happened at all. Yes, he came to the work site, but he carried on. He acted like a bit of a dickhead, and he barked orders at everyone, and we all ignored him, and then he went on his way. And I said, thank you, kind builder. Would you like to come over and make an affidavit to that effect? So he did, and we did. Then we got to the interim hearing, got to court, we had all of our material, and after half a morning of arguments, he decided to withdraw his application. Now that kind of ticked me off because I thought I was on a winner, and I was really looking forward to seeing the judge dismiss his application, because what that meant for my client is that then we can make an application for costs. Now in family court, costs aren't generally ordered, but in a matter like this, it probably could have been ordered. But anyway, because he withdrew it, it wasn't. So my client had the cost of me being there for the day and the cost of preparing for it, and she also had the time that it took out of her life. So, not the best. But let's have a look at what an actual relationship is, what a de facto relationship is. Because aside from those two things, if you're considered to be in a de facto relationship for 2 years, then you can make an application. Now, most people think that de facto means living together as a couple. Is that about right? Lots of nods. Yeah, it's actually not. Actually not. This is the definition. Having regard to all the circumstances of the relationship, they have a relationship as a couple living together on a genuine domestic basis. So that kind of sounds like they're living together, doesn't it? Living together on a genuine domestic basis, yeah. However, let's have a look at the circumstances. So these are the things that the court has regard to when deciding whether or not you're in a de facto. So they have a look at the length, they have a look at the nature and extent of common residence, they have a look at the financial dependence or interdependence, whether a sexual relationship exists, they look at shared property, they look at the degree of commitment to a shared life, they look at whether or not your relationship is registered under state law, they have a look at the care and support of children, and also the reputation and public aspects of the relationship. But what scares me is this subsection 3, and that says no particular finding in relation to any circumstance is to be regarded as necessary in deciding whether the person's had a de facto relationship. So none of those things are necessary. You don't have to be living together. You don't have to be sleeping together, but you can still nonetheless be considered to be in a de facto relationship and make an application to the family court, or have to respond to an application to the family court. And what's going to scare a lot of people is this subsection 5b. Now that says that a de facto relationship can exist even if one of the parties is legally married to someone else or in another de facto relationship. And I heard someone say the word shit just then. It's not a good thing, is it? I mean, it's potentially hazardous. So be careful. But let's have a look. I mean, I consider that to be immensely unhelpful. Immensely unhelpful. But let's see how the judges interpret it. So we have this case that came before, I think it was 2012 decision of Shelley and Markhov. Now they had been living together for 14 years. They owned property together. They were sleeping together. Members of the Thai community, sorry, I might just point out, the Shelley, the female, she was from Thailand, and Markhov was a doctor from Bulgaria. So members of the Thai community saw them as being in a relationship, or being a couple. And they also attended social functions together. So when you look at that, would you think that that's a de facto? Yeah, again, lots of nods. No, that's not a de facto. Shelley said that they were living together as a married couple. Markhov, he thought that they were housemates who were friends with benefits for 14 years. The court accepted what he said. They found that because Markhov had subscribed to internet dating sites and chat rooms, he tried to have a crack on a couple of Shelley's friends, and he told others that he was searching for a life partner, and because of that, they couldn't be considered to be a couple. They also played a pretty limited role in each other's family lives, but that was because wifey, or can't call her wifey now, but Shelley from Thailand had all of her family in Thailand. Markhov was from Bulgaria, and all of his family were from Bulgaria. So they weren't being involved in each other's family lives simply because they were not around to do that. But anyway, I might say also that was a decision of the Western Australia Family Courts. Now, WA is the only state that doesn't actually follow the Family Law Act and the decisions of the Family Court of Australia. So in Queensland, basically that decision isn't binding on our courts, but it is interesting. It's interpreting the exact same wording as what the courts here will interpret. But let's have a look at a Queensland decision. This one came through in the last year. In this instance, the parties didn't own or share any property together. They didn't pool their financial resources. The person asserting that they're in a relationship actually signed some central documents during the relationship saying that she wasn't in a relationship. There was also some evidence to suggest that she, person asserting the relationship, was in a relationship with someone else, particularly towards the end of the relationship. If I can call it that, I don't know. However, the parties kind of sort of lived together, but not really. It was known each other for a period of 10 years. Sometimes she'd move in with him while she was renovating. Sometimes he'd move in with her when he was renovating. But it was never for big chunks of time. So Allenby said they shared a bedroom and Kimble said they didn't. Allenby was the person asserting that they were in a relationship, so that was convenient for her to assert that they were together. But they also attended family events together. They travelled together on holidays, and Kimble renovated a room in his place for Allenby's business. So do we think that that's a de facto? Not really. Not really? Yes, it was. Yay. Those 4 factors were enough to conclude that they were living together in a de facto relationship. Go figure. They weren't living together, but they were living together in a de facto relationship. What terrifies me from that is a statement made by Justice Merthyr. It says, individual or broad community perceptions of what might constitute a de facto relationship, including the individual perceptions of the people who are in the relationship, are not determinative of whether or not the law so regards it. How bloody scary is that? You may not think that you're in a relationship. Society may not think that what you have is a relationship, but that's not going to stop the court from finding that you're in a relationship. WTF. I mean, that's ridiculous. But that's how the law stands now. Hello, Bruce. No comment. No. Video evidence about what though? Again, it doesn't matter. It doesn't matter if you're having sex. You can not be having sex and be in a de facto relationship if you have a look at those factors. Look, if there was video evidence, it probably would have been accepted by the court because the court does like to hear whatever is available, particularly if it's interesting. But there you go. I mean, to me that says, hello.
Are these all Queensland decisions? From the Western Australian one?
They're all Australian decisions, so decisions of the Family Court of Australia. So we follow that in Queensland. So all of those are binding on us here. Yeah, this decision was made by Merthyr in Brisbane. It was an appeal, so if it went on appeal, it's interesting. It would be interesting to see how the Court of Appeal or full court of the Family Court would deal with it. I'm being told that I'm taking too long. Does anyone have any questions? Oh, sorry, BFAs are great. I had to get that in. BFAs mean that that someone can't bring an application because you have an agreement there that sets out what's going to happen to your property in the event that you separate. So it's a really good protective measure. However, be careful because if a BFA is drafted and not signed, that could potentially be evidence later on that you thought you were in a de facto relationship. So, hello.
When you get married, there's a certain moment where you sign a bit of paper, and immediately after that you're married.
Yep.
Now, a lot of those conditions for determining a de facto relationship, if you apply them then to that marriage, despite the fact that it's signed a bit of paper, it wouldn't be a marriage. So, if we're going to go in, so if we're going to go into a de facto relationship, maybe we should sign a form which says, I'm in a de facto relationship.
You make a really good point. And that's what scares me about this thing. I mean, in my view, if you marry someone, you agree that at some point they can take your stuff. Like, it's just a given. Maybe it's 3 years or 10. Maybe I've been in family law too long. But it's a given. That's what you sign. That's what you agree to do. Because you love them or whatever other reasons, that's what you agree to do. But this de facto thing, you can be in it and not actually know. And I think that that's incredible. And yeah, you should have to sign something. acknowledging that you're in a de facto, and that would get rid of a lot of these concerns that I'm now having and that probably some of you are having.
What about prenups?
Well, they're the BFA. So a prenup is the same as a
So
BFA.
it's the same thing?
And Stephen will talk a bit about that as well and its impact and uses. But a prenup is a fancy word or an American word for a binding financial agreement. So in those you can set out what's going to happen to your property if you separate. And it can include whatever you want to include. It can either be, right now, my stuff I'm going to keep and you can keep your stuff, and anything else that we buy during the relationship will split. Either you get half or I get 70% or whatever it happens to be. But it can really be whatever you want it to be, and it avoids the court. Hello?
Hello. Just where you're living or whether you're an Australian citizen or not have an impact. For instance, that Shelley girl from Thailand, if they were living together in a de facto relationship in Thailand and they were both Australian citizens, or one was and one wasn't, or if they were living here and they were Thai citizens,
yeah, well, it
what
depends
jurisdiction do they come under?
Depends on where the property is. So if all the property is owned in Thailand, then they'll come under Thai laws.
I see, okay.
Yeah.
So what about the person who has the property here?
So then they come under Australian law.
It's under Australian law.
Yes.
So that person, even if they're not an Australian citizen, can still claim on it.
Yeah, that's right.
We might have to wrap up now.
Oh, there's a few questions. Sorry. Actually, do you want us to come see me afterwards?
No
That might be
specific
easier.
questions, if you could talk to us during the break. One more, Jay.
Just a very quick one. This is in relation to special contributions.
Yeah.
What about scenarios that you hear out there where one of the spouses doesn't have any skills, gets the lion's share of the assets of the marriage, because the one with skills can go out and work for the next 20 years?
What was that? Sorry.
So in relation to special contributions,
Yep.
you hear scenarios where the spouse with special skills is awarded less because
Oh,
they
yeah.
can,
So
they
that
can do the work.
that comes to this. Anyway, it's in page 3 or something of your notes, but it comes down to the 4-step process. Now, in step 3, the court has a look at what your earning capacity is. So if you have a really good earning capacity and wifey doesn't because she's stuck at home with the children or because she hasn't been in the workforce, then the court will order more in her favour to take that into account. But that's quite different from this special contributions thing. So that comes in at the assessment of the contributions. So the court makes that assessment, and then it makes another assessment based on earning capacity. And it has to be more than being able to generate a good income. You have to be able to convince a court. And keep in mind, 90-something% of matters actually settle outside of court. But if it goes on to court and you can argue special contributions, then you're not going to see a greater adjustment to the other person. Anything? Oh no, no more questions, I'm told. Right, thank you very much.
Thanks, Jacinta.